Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Ikram Hakim bin Zulkifli. So today I and my friend will talk about estate planning. So let's start with the definition. So estate planning is the preparation of tasks that serve to manage an individual asset based on the event of their incapacitative, or in the simple way we call the debts. So the planning includes the bequest of asset to their heirs and the settlement of the estate tax. So most of estate plan are set up with the help of attorney attorney that have experience in the estate law. So example of estate planning is takaful, ASB, house, land, shares, or others valuable asset. Valuable asset that under the name of the deceased. Moving on to the type of estate plans, there are three types. So the first one is we call harta pusaka ringkas. So this harta pusaka ringkas is the current asset which is valued less than 600,000 and it handled by the Amanah Raya Berhad. The second one is harta pusaka kecil, or this asset is the current asset and fit asset which is valued less than 600,000 ringgit and it held by the pejabat pusaka kecil. And the last one is harta pusaka besar. So this is the current asset and the fit asset which is value more than 600,000, and of course it's will held by the higher court. So moving on to the objective. The objective of estate plan is to ensure that the maximum value of the wealth is distributed to our dependents according to the our genuine wish. So this means that we decide we desire to minimum leakage of the estate to the government and the orders in the form of tax and administrative charge. So after that, let's look at the strategy of estate planning. We can see here there is 5 strategy. So the first one is protecting asset. So the protecting asset is the one should seek the secure and risk minimizing method to protect the intrinsic value of the asset. So he or she should allow the continued growth and increase in the profitability and liquidity. This will avoid the problem of insufficient income provision for the our heirs. So second one is the maximize the amount to our heirs. So it is important because to preserve the maximum amount of the wealth to or for the distribution to our beneficiaries by minimizing the estate settlement costs and any others tax associated with our estate. So this may involve giving gift or what we call hibah while he is still alive. And the third one is minimize administrative costs and inconvenience. So the example of it is writing a will or we call wasiyah, which is critical component of the estate of this estate plan. So it will shorten the lengthy court procedure and hence the administrative and legal costs. So it also economical and faster as it enable the grant of the probate rather than letter of administration. So the next is appoint capable executors to manage the estate. So the executor is responsible person for administering and distributing our asset after we dead. So the appoint of this have to be individual that have trustworthy, financially competent and honest. So the last one is appoint trustworthy individual as guardians. So in this case, in case where our beneficiaries are minors, so we need at least 2 legal guardians. So the role of this guardian is to hold our asset, invest and use them for the benefit of these minors. So this individual must be trustworthy and genuinely care for the minors. So let's look at the procedures in developing sound estate plan. So the first one is ascertain how our asset ascertain the asset of our own. So first one, we have to itemize all our asset like liquidity asset, financial asset, real properties and personal properties. So we have to determine the proportion of ownership in each asset. So the second one, we have to determine how we want the estate to be distributed. So the first one, we have to list all the individuals or beneficiaries whom we like to transfer our asset after we die. So we have to decide what proportion of our wealth we wish to allocate to each beneficiary. So for example, to our wife, to our son or daughter. So the third one is we have to decide on the means of transferring asset. Distribute our asset either during our lifetime or after we die. So while we are living, we can distribute asset to our beneficiaries in the 2 ways. So the first way is direct gift. So what is direct gift? So direct gift is like such gift have the advantage of avoiding the estate duties as well as seeing our beneficiaries enjoy this gift while we are alive. So the second way is we can see in the last point, that is decide on the mean of transferring asset. Second way transferring the asset while we are alive is set up a trust to distribute our asset to our beneficiary. So after we die, the asset can be transferred to our beneficiary in the form of will, trust, intestacy law, and beneficiary designated in the contract. So I think that's all for me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. I am Muhammad Amir Akmal and I am going to continue the presentation by stating the ranking of asset redistribution. The first rank is to discharge all obligation. After a Muslim dies, all things related to the world are cut off except three things, which are alms that continue to benefit, knowledge that is utilized, and pious children who pray for him or her. Therefore, it is the responsibility of the family of the deceased or heirs to discharge all of his or her obligation relating to the zakat, various kafarah or penalties for oath, zihar, coercion whilst fasting in the month of Ramadan, and coercion whilst in the state of ihram during Hajj and Umrah. The second rank is to pay for the funeral expenses. After the death of a person, the first thing that needs to be expedited is the matter of burial of the body. The costs and the expenses of the funeral have to be borne by the estate of the deceased. Among the costs of the incurred through the estate of the deceased are the purchase of the shroud, the purchase of the toiletries, grave digging wages, funeral transportation fee, and other funeral related costs. Other costs and expenses often incurred by the Malay community for the purpose of tahlil, payment of consolation money to individuals who pray for the body. Tombstone wages are not the responsibility of the deceased estate and cannot use the deceased estate to finance such costs and expenses. The third rank is to settle all the debt. Paying off debt is an obligatory thing in Islam. There are many hadiths related to the punishment of not paying debt. When a person dies, the property left by the deceased must be used to settle all his or her debt. The settlement of such debt include the performance of the Hajj and on his behalf if he had not already done in his lifetime, and the payment of mahar if the payment had not already made. Therefore, the payment of the deceased debt in the second top tier that need to be made in the management of the deceased estate. If the deceased has not have no estate such as not movable or immovable estate, then it should not be up to the heirs of the faraid, including the wife, to settle his debt. The fourth rank is to execute his or her will. A will is neither a contract nor an agreement between two or more persons. Only after the testator's passing does not document the actual legal status. Jumhur Fuqaha stated that a will to inherit is not permissible, or a will is not valid made to the non-heirs who receive a share of the property under the faraid rule. Based on this view, the legal origin of the will to inherit is invalid unless the other heirs agree to the will that made by the testator. Last but not least, the fifth rank is to distribute all the remaining estate among the heirs. After all the above is complete, the estate can be divided according to the law of faraid or depending on the agreement of all parties. Next, I will explain about the method of asset redistribution. The first method is will. Basically, every individual who wants to put their affairs order by taking advantage of their design, the initial estate can make a will. For Muslim, only 1/3 of the total inheritance can be given to non-beneficiaries, while the balance must be distributed within according to Islamic faraid law, aspect where the legal beneficiary of the testator agree otherwise. On the other hand, for non-Muslim, one can determine the way how to hold asset distributed after his death through a will without any redistribution. The second method is faraid. Property management after death is the division of the inheritance which is subject to the faraid law. Sharia has stipulated that when a person dies, his property will be divided according to the division of the faraid. Faraid division of property is one of the way of property distribution in Islam. The form of property that can be divided by faraid are land, building, jewelry, insurance and cash, and livestock such as gold. Last but not least, the hibah method. Hibah is a transfer of property without exchange of consideration, with a defined proposal on the part of the person who give the gift and acceptance of the part of the person to whom gift is given. In Islamic estate planning, hibah is a present that is given to an individual during a lifetime of the giver, or in the estate distribution of the deceased, such as adopted child. Law or Sharia given freedom to property owner to make gift without being bound to a certain rate, unlike faraid, which is only 1/3.
Assalamualaikum warahmatullahi wabarakatuh. My name is Ahmad Najmi bin Ruslan. So doctor will go through the first one, the will. So I will explain to you about the will and also the definition. So currently I found about four difference of the will. The first one, the definition of the will is the legal document that speak out the wishes of the deceased person regarding their care of their children, and also the distribution of their asset and estate planning after their death to their family. So for the first one, the first difference of the will is the will is only apply and also occur after the death of the giver. So that's mean as long as the giver is still alive and not die, the will is not happen. And the second one, the will, the property maybe consist of the property or also the debt of the giver. So my third point of the difference of the will is the recipients must came from the person who related to the deceased person, such as your cousin, your nephew, your niece, your son, your daughter, your spouse, and also your parents. Difference with the hibah where you can inheritance or transfer your asset to other people, including the non-Muslim too. And also the last one, there's a current limit where only a third, 1/3 of the total inheritance that can be received by the recipients. And last but not least, and also there's a term in Islam we call mane, where the deceased person, if he got killed by his family, then the person who killed him can inherit his wealth as well. Doctor will go to the next point of hibah. So I will talk to you about the definition of the hibah. Hibah meaning the granting of the ownership of one property from one person to another person without any consideration. And also there's a condition where there's a certain ijab and qabul that was made by the giver to the recipients. So there's also four difference of the hibah. Then the will, for the first one, is the opposite of the will, whereas hibah is the gift given by the giver to the recipients, either when he or she is still alive or after she or he is dead. And the second one is the will can be transferred to the recipients, can be consist of property and debt, but for hibah is only property. So the third point of the hibah is complete opposite to the will, whereas if the will you can only give to your family, but hibah you can give to your other friends too, and also for your non-Muslim friends too. Might be as the token of the gratitude or as the token of the friendship for them. And also, and the last one is if a will you there's a limit, a third of your total inheritance, but different cases for the hibah because there's no limit, and also based on the consideration of the giver as well. So last but not least, the last topic, I will explain to you about the role of the Sharia court in Malaysia upon the asset redistribution and also the estate planning of the deceased to the people who are still alive. So for information, I will tell you about the history. So currently there's two different court in Malaysia. One is the civil court, and the second one is the Sharia court, which lays the foundation, and also they will do the judgment, the judgment and also the jurisdiction upon only the Muslim in the Malaysia. And it was established since 1952. Way back before the independence of Malaysia in 1957. So if the people or the public found out the deceased person left their will, or we call jointly property acquisition, which means in bahasa mata sepencarian, they can seek their advice and also can ask the Sharia court to take illegal action upon them. So if they do not agree to their term to each other, Mahkamah Court will handle the case because they have a certain specialist and also the experts that can handle the matters. So for the next step, the Sharia Court will determine the properties, will determine the rights of the beneficiaries regarding the will of the deceased person, such as who has the right upon the deceased property, and also there's such a specific knowledge in Islam which related to fara'id. There will be some expert and also the specialists who specialize in the ilmu fara'id, which handle basically the inheritance in Islam only. And the final step, the Sharia Court will issue the inheritance certificate of application of the applicants if they seek the wealth or the property of the deceased person. So in that case, the court will seek and also will check all the facts that was given by the applicants about the information regarding the will, and also will check about the relation between the recipients and also the deceased person. And the last one, the property will be distributed firmly and fairly to the recipients if they found out the recipient is legal and eligible to receive the property based and according to the Muslim law. So that's all from me, sir, doctor. Thank you.